This is what they sent out.
I don't know. I'm the last person you wanna ask me.
Okay. I got feedback for you, if I want to. How to order. I know, I'm assuming that the hospital all that taken care of.
Your presentation.
This is what I
Hi.
mean. Last
Oh my
slide.
goodness. I always need a refresher. That's always something, as you know.
Yeah, I always said the same.
That's not exactly what I said.
You know what? 30 years of this business, it'll beat you down, so it's.
Yes, it will. You realize
Whether you like it or
you've
not.
forgotten more than you used to know,
That's
right?
right.
You know, when you think you've seen everything.
Oh my gosh,
I saw something
heavens no.
today.
I say it's every single day, I
Swear.
swear.
We had a native attorney. So,
Yeah.
no.
But here they're next, but they're not. It's fine.
Way out there.
Thanks. Also, I said.
Day by day.
Did you know you did?
That's the only way you can do it, right?
Yeah.
Oh, yeah.
But-
Stay.
You're very wrong.
I did too bad, huh?
Okay.
Yeah, I go like, so many. It's right. At some point you gotta come out.
But yeah, it's all went together. Yeah, we've been going down there. since I was-
I already familiar with our exit time. Yeah.
That's what I.
At Austin.
I've been down there.
I don't know. So I live with my boyfriend on his parents' property. And so they have 3 houses on it.
Oh, yeah.
Right?
Yeah.
And yeah, so we lived over there one of the.
Lots of things, but never that.
Yeah.
But I'm still like, down there, I think just around us, there's 3 new neighborhoods going on. So I just gotta find a way to break into that market.
Absolutely.
Yeah.
So
Good.
what we need to recognize is that.
Mobile homes.
The revoke, the title has not been revoked from the state, so it's just like selling a car,
Yeah.
like an airplane.
Remind me of that conversation on table, especially I watched. football.
Yeah.
Whole family contract. that's why.
Yeah, right.
Yeah.
Good stuff.
How would I go about it? Do I try to get a lawyer for this?
Yeah.
I'd be a need for something like that, but most people in dealing with those kinds of things. The first big step is finding out what the community requires. That's gonna be important.
I just have chosen something harder to start with.
You know what, it's a great learning exercise, right?
That's for sure. Yeah. Would be
We have our experts here, they're gonna get all okay with me working. Notice they walked right past me and didn't ask me for any tech advice.
Okay, that's, yeah.
For smart
I've
people.
got friend who's kind of the lake house up on, good, well, near Junker, it's like right outside of it.
Yeah.
It's not scary.
That's wrong, like I said, I mean, that's.
It's so.
What did you say?
Not today. Yeah.
We always have
I think
a hangover.
Right.
Pretty busy the first few days of the month. That's one where you can get. We had one yesterday, I think we had one on Friday, but.
You aren't gonna find cleanup down there.
We did a few classes.
Yeah, I see. And tell me about the meeting, Sam Carter on the 20th, this month.
Right, that's one, well, what I'm saying is he's coming to use that class. And he's like.
Running around.
Yes, the class on.
Yeah, that's everybody's dying.
Okay, so everybody listen up. So the materials for what officers get ready to do. Are you saying they can, scan this QR? Oh,
Or
and they
type
had-
in that code.
or type in the code? Low code. Oh, okay. So that way you have the material about the closing stuff that Austin's gonna be talking about. Thank you, Caitlin. So are we, now tell me on the Zoom thing, do we have people
Yeah.
on the Zoom?
Good.
Yeah. So if you've got a mobile device, whatever that might be, scan the QR. I even know how to do a QR, and if I know how, everybody got to know how. I had to have it explained to me several times by my daughters. Okay, is that like the camera part? Is that, what about?
Yeah.
There you go.
They had to explain it to me. All the times.
You get high tech. I love it.
It's only because of consistent harassment. It's just. The good thing about being an aged person, nobody expects you to know anything about tech. I need to know something about everything else. So if you want to do this because he's going to talk about stuff, and let me talk a little bit about Austin and what I wanted him to be able to do. This is Austin Knight Trust Title, which is right across the parking lot. We're here. And did you start? January, February, what?
We started accepting, I believe we got our first orders late January.
Okay. Up and going and, clearly they decided to do title business because it's incredibly lucrative and very easy. Is that how that works?
Like selling TVs, right?
Yeah. Or like going in real estate, you need quick money, you get a real estate license.
That's right.
How hard can that be? Depends on if you want to sell mobile homes or not. There are mobile home salespeople there who, one of your challenges, because one of Natalie's first deals is a mobile home on a lease lot in a mobile home community. And part of the rules that the community has about whether, what can, or if who owns the mobile home, what can you do? What can you sell? If a person wants to buy it, can they stay on that lot? Can they lease it? I mean, all these things. But one of your competitions, depending on the mobile home community, are the mobile home salespeople. Who would rather be able to sell new mobile homes or sell lots and things like that, rather, because you may be their competition. Depends a little bit on the community and kind of how that works. And, we face that all the time in the business. We're talking. Jeff, you want to introduce yourself? Because you're sitting here. He's our lender person here. Benchmark. You have to stand up and.
Hi.
How are you? I'm Jeff Simpson. I'm with Benchmark Mortgage, which is right around the corner and just started 3 weeks ago. So
Great.
Like to be
I
here.
appreciate it. Thanks for having me.
Absolutely. So the concept of what I wanted Austin to try to do here. Because when all the things that happen, if we're dealing with a sale or a purchase as opposed to a lease situation, our final proof of everything happened right was closing, which is in Texas going to happen in a title company. It's interesting, in some other states, it happens in their broker's offices. In the Carolinas, they close in broker's offices. Way back when I first started in real estate in the 60s, we did that. Brokers had their own escrow accounts and it was a whole different animal. We learned as brokers though very quickly to figure out we don't want an escrow account. We don't want a trust account. It was a lot of hassle, even as poorly regulated as it was back then in comparison to where it is today. So, not being a closing expert, but understanding the process. What happens as we get up to it, things that happen in the contract that involve the title company, all the way from the title commitment to if there's an existing survey and a T-47, the title company is the one who's going to approve that. If you go through that, you understand that. But at the very beginning, if you've got a buyer and you're going through the process and your buyer is able to get into a contract, and that contract is going to go to the title company. That's going to start everything. In fact, when you look in the contract itself, which after it gets through, we're going to talk about some things in the contract. In paragraph 6B, which deals with the commitment, it establishes that once the title company has a copy of the contract, the seller, not the title company, but the seller has 20 days to provide that commitment to the buyer. Now, we don't say the title company because why?
They're not a party to the contract.
Exactly, they're not a party to the contract. Way to go, girl. So they're not a party to the contract. So we can't make them do anything. So they do that. Now, there are situations, and I'm happy for you to expand on it. I'm really setting you up here on all the things that we're going to be talking about. Occasionally, you'll have a transaction in which title has already been opened. And you've experienced that over time, and there are a number of different reasons. One, a deal fell apart and title had already been done, and we're going to meeting to the next buyer, maybe on a backup. Maybe it's an estate situation. There are a number of different scenarios where they've already opened up title. Sometimes you'll have a big time owner who's got contracts with title companies. I'm sure Sam Carter has some of that, where he's got that. So they've already got this set up. So they've got a lot of title opened up. So if you've got the buyer and the listing agent is saying, well, here's the title company we need to use, we've talked before in other classes about choosing the title company, whatever. Your immediate thing is, okay, that's fine, but tell me why title has already been opened up. Because sometimes they're not good reasons why it's already been opened up. Maybe there are problems that they're still trying to work through. So you always want to know, because once you have a contract and you get that contract to the title company, they can start their search and go through the process where they're going to issue a title commitment and deal with all of that. And in that same paragraph 6B that says that, the seller has 20 days to do it. In that same paragraph, the seller authorizes the title company to do that. So that kind of starts your whole process. So talk to us a little bit about what happens at your company. You get a contract, as you go through the process. What do you look to the agents to help in the process? What do you need from us? Because we need to make sure that we're doing things that work well for the title company, which is going to work well for our client. So.
Absolutely. So we receive a copy of the contract. It's executed by all parties. First thing we're going to do is we're going to receive that contract in. We're going to send an email to the seller side, a copy of the received contract, an email to the buyer side, we receive a copy of the contract. On the buyer side, we will also have options for earnest and option money to come to us. That's Zochum, and that's also wiring insurance. So this is right to us. Once we receive the buyer's funds, we receive that in, and you have the receipt page on the back of the contract that we send out to all parties showing the option earnest has been received. Okay.
What do you think the time frame is on that?
What do I?
Day, 2 days, 3 days? What should we be expecting to get from a title company confirming receipt of?
Receive the contract will be within an hour or two. Yeah, we're going to try to get that out to you right away. And that's just to make sure that more than anything at that point in time is to put everybody's mind at ease, right? The contract's been received. We started the process of getting title opened. The searches have started with the underwriter and the plant. And more than anything else, that means we've sent out instructions for the buyer to send us option earnest money. Because that's the biggest determining factor up front, is making sure that the buyer gets their option earnest money in so that you have a valid contract. So at that point in time, we have the search that's underway, right? We're currently, at that time, it's all just kind of sitting there. We're waiting for our underwriter to get us back a copy of the search. So the search will come back. They'll go in, they'll pull all that information and they'll create a commitment to ensure, right? The commitment comes back and it's clean. We automatically send out to all parties saying, here's your copy of your commitment. We'll go through, we'll order HOA documents unless you ask us to do that up front, or unless you ask us to hold off because you don't think it's gonna make it through options. Sometimes you guys will give us a heads up and say, we're not sure we're ready to do this yet, let's hold off. At the same point in time, hopefully we've already had a seller send us the survey. Right? If we have a survey T47 that we need to have reviewed and approved, we'll send that over. If there's not a survey and this isn't a contract that one needs to be ordered, we'll go through and we will try to get that ordered according to the contract and who's supposed to pay for that. Right, so all of the stuff that we're doing so far is based on the negotiations of the contract that we've had up front. That's been given to us by you guys, okay? At some point in time, we're gonna have a clear title commitment. We're gonna have survey back. We're gonna have HOA documents back. All this stuff is gonna be delivered. We're gonna reach out to you guys. We're gonna try to schedule the closing, the signing itself, okay? Once that goes out, we'll have a copy of the final fees that go out. We'll have a scheduling date and we'll have reminders for the items that are, you need to have at closing for both buyer and seller.
So what are the things that pop up that we haven't done or could do, or our clients haven't done, that we need to be aware of to make sure these things get done? I mean, you've got to have surprises, things that happen, things that but we need to make sure as an agent representing a buyer or a seller, that certain things are taken care of, certain things are done.
Absolutely. So, and our agents are honestly very good about this, but if you have any kind of an inclination that there's going to be a deceased party on title, please let us know ahead of time, all right?
Remember, dead people can vote, they can't own real estate. Depends a little bit on what state you're in.
So this would be an instance when title has already been opened. You have a buyer and they say title is already opened on another title company. And you ask why is title open on another title company? It's because we see dead people, right? So if you think that there is a deceased, yes, if you think there's gonna be deceased individuals in our title, please let us know, give us a heads up, and preferably let us have a head start, okay? Another thing that would be really, really helpful for us is if you explain to your sellers that we have no control over the HOA fees. We have sellers that chew us out all the time because of the HOA fees. We have zero control over the HOA fees and what they cost. And I know that there's a new rule, there's new legislation that says it caps how much the resale certificate costs, but now we're seeing just additional junk fees, right? It didn't change anything with the actual cost of the seller. They just created additional fees that they're passing on to them. What else? Yeah, let us know ahead of time. If you feel like this is a shaky deal, we don't think it's gonna get through option, let us know, right? If it's something that is gonna have a lot of work, right? Often we'll get that title plat and we're gonna start trying to dig into it. We're gonna start trying to get a process as soon as possible. Our whole goal is to try to get clear title and get everything cleaned up and done so the file is just sitting there. And if you don't think it's gonna make it through option, let us know. And we can kind of push it off 3 or 4 days just to make sure that everything is lining up appropriately. As much as we all like to believe it, it's not the only file that we have at that point in time, right? So let me think what else. HOA fees, dead people.
If you have things like estates, probate, trust, there's certain documents, HOAs, there's certain documents that the title company is going to need. We like to, rather than say our client, well, we've got to have a copy of the trust, the will, we lay it off on the title company. So here's what the title company is going to need, because you'll need certain things, just like if you've got a seller that they're an LLC, even though as an individual they have signed, they've got to have authority from that LLC to convey title.
Anytime the buyer or seller is an entity and not a natural person, there's going to be documentation that supports that. Just know we need that. We have to have it. It's not for us, it's for everybody. Everybody's got to know that this individual has authority to sell the property and they are who they say they are. 9 times out of 10, to be honest with you, when we get a contract over that has the entity for a buyer or seller, it's not right. It's usually just not right. And we have to do some kind of amendment that says that, no, it's not this particular individual, it's actually the trustee of this entity who needs to be the seller and vice versa. So just get us that documentation as much as possible. And obviously, we will be asking for that whenever we get a copy of the contract, but just know off the top of your head that if the seller is not a person, If there's some other type of entity, there's gonna be documentation that we're gonna require in order to support who that individual is. And that they have the actual authority to sign on behalf of that entity.
You understanding that as an agent, having a sense of what's gonna have to happen and who has that requirement. It keeps you from being in the middle of it, but it also gives you that opportunity to prove up your credibility, in the fact that you have some expertise, that you understand, here's a process, here's how things happen. Here's what happens, here's when it happens. Because as they're sitting there, with the contract and going through the process and getting their commitment, they've got certain steps, they've got certain things that they work through, that your processors, underwriters are going to work through. And as they work through those files, we need to make sure that we've communicated to our client. You understand, because of what I do in this company and in the business, I get the phone calls and I get the situations that hopefully none of you in this room will have. But when I get a call the night before the closing, and I find out we didn't do this, and this, and we find out it hadn't been through a probate, independent affidavits and which is something we should have talked about 3 weeks ago. One of the things that you need to remember about me, first of all, it's not the principal's office. I'm not a bad guy. I'm here to help you out. But I prefer permission over forgiveness. Make the call sooner rather than later. Because not only is it good from a liability standpoint, it helps the title company to be able to move forward and close and go through the file. It helps your client. You work through the process. Because, one, we want our client, buyer or seller, to have a good closing. You buyer get the house, seller get your money. But from my perspective, I've got an agent who's done a lot of work in this thing to a closing. I want to see they get paid. I want to see that happens. And it really hurts me that when things happen, that's not going to happen. I get very unhappy and I immediately look for, where's the glitch, what happened? And the title company is such a huge part of it. They have so much influence on making decisions about so many things. And that's part of what we're doing is helping us understand, here are the documents, here's who has to sign, here's why they're signing things, here's how this works. So that you've got, even at the 10,000 foot level, you've got this overview of everything and how it works. And you know what you can do to help the title company. Because when you've got good relationships with good people at the title company, that makes such a difference in the transaction. I mean, it's just night and day. When you're dealing with, and the most often time that I see is sometimes you're dealing with a title company attorney. A title company that's owned by the builder or has a relationship with the builder, and we don't get the service level that we would get from typical good title company or good title companies. You got to deal with it. And by knowing the process and what they're supposed to be doing that you're not doing, it's going to help you kind of work through everything.
And if you guys can, and I understand that I don't think like everybody else thinks. I've been doing this for 20 years. To me, it just makes common sense that if you're an entity that you would know, you need to have supporting documentation. To some of these sellers, they don't know, they don't care. And we had a file not long ago. Actually, I saw Janice Kima was on this call. So I'm not naming any agents in particular, but we had a situation not long ago where the seller, we asked him for supporting documentation for who he was, the authority to sign on behalf of the entity that he was holding property in, or excuse me, that he was purchasing the property in. And he said, look it up, Secretary of State. So we look it up, it's not filed, can't find it. Go back and forth with this individual 3 or 4 times. He finally comes up to me and says, look, we went to Office Depot, we got a package, we created this entity. I don't have it. I don't know what you're talking about. I don't want, So we almost had to delay closing. We had to escalate this up to like 3 different levels of underwriting attorneys as an underwriter before they actually approve us closing with this individual being an authorized seller. So just knowing ahead of time to prepare your buyers or sellers that we're going to need documentation for that is a huge benefit for us. Because a lot of times we'll call them, they don't know us from Adam, we're asking them for documentation, they don't know where it's at, they haven't seen it in 10 years. And frankly, it just frustrates them. I don't have time to deal with this, I don't want to deal with this, I don't know who you are. So just prompting them to know that we're going to be calling for it, we're going to be looking for it, helps us out at time. It really does help us out at time.
We've talked about this in other classes, but one of the challenges for title companies are fraudulent sellers, which is why they kind of have to take those extra steps. It's also a problem for us as we go through that process. We want to make sure that we don't put time, energy, and money into a situation and it's not real. We've had those challenges. We've had them in this office, I've had them in my Rockwall office. Where, we didn't find out, Fortunately, at some point in time, you find out, and it's mostly acreage and vacant properties, but those have increased, and the title companies are really trying to stay on top of that. Because it's a real challenge. I don't want to be in a situation misrepresenting the availability of a property to a buyer. Who thinks they can buy the piece of property and go all the way to closing and give somebody money and find out they don't own it. Because the person who signed off on it didn't own it.
And you don't want to waste your time going out into the middle of nowhere to put a sign for a listing out in front of land.
Although that's how we usually find out, by the way. When we stick a sign in that acreage and we get a call from someone other than the one we thought was a seller. Sometimes that's our first big clue. You gotta, oh, well, who are you? And then, of course, you have the problem of maybe this is the second level of a scam. So the guy called you, doesn't own it either. So you have to constantly be working through that, but it's just, but that's one of the claims that title companies have to deal with. That's fraudulent sellers. It's just challenging. So we need to be very careful. We've talked from the listing side that we need to take extra precaution, especially if it's someone that everything you're doing with them is online, text, email, you don't ever meet them, and it's a vacant property or an acreage. You need to go through the process and push for things like IDs and things like that. Go through the process, and even that's not foolproof, but you got to try and you got to do something. Because the final step of everything is at the title company, and they do a great job of saying, well, we've got to have this, this, and this. And for fraudulent sellers, some of what they title company needs, they just can't do it. Like that guy you talked about, well, I don't know where to have it.
Right.
Just made it all up.
And if we get a seller that's a little bit fishy like that, the first person we're gonna call is you guys. Say, hey, have you ever worked with a seller before? All right, okay, you haven't, all right. Did you meet with them face to face? No, you didn't. Okay, do you have ID? How did you get ID? Okay, it was emailed to you. So we had a scenario, one of our sister companies not long ago where it was a fraudulent seller and they had ID. They had a fake ID. So just because we have ID doesn't necessarily mean that that's who they really are. And unfortunately, there's still no public database to verify IDs at the state level and the national level, which I think should be. So just be careful if somebody calls you and they're trying to get something sold right away and they don't want to meet with you and you've never seen.
Yeah, that's a sign. They're in a hurry. And it's a great price, and it's, those are big signals. Yep, they're great flags. So as you go through the process, we know different title companies do things different. And we've got a lot of really good title companies up here. Trust Title is one of them. Republic Title is one, Chicago Title, Allegiance Title, Lawyers Title. We've got a lot of good title companies up here. But you need to be familiar enough with the closing process to know that they all do it a little different. Now, they all operate under TDI rules, Texas Department of Insurance. But I would presume, you can correct me if I'm wrong here, that some of those rules are open to a little interpretation. And some title companies are a little tighter and tougher on it than others.
And some of that interpretation is whether or not you get caught.
Yeah, that's true. Because remember, no matter what decision you make, you're right if you don't get audited.
That's right.
It's just not a problem.
That's right.
So as you go through it, you have to be able to do it. So as you understand that process, you'll know what to expect. And if you don't get certain things, I want you to always feel confident to ask the question. Ask the title company certain things you know that they ought to be aware of, they ought to be on top of, they ought to be doing. And if you really don't get really good answers as you work through the process, call me. Or call one of the title company attorneys that we do business with. And they'll say, oh, yeah. So they can't do that. Because the stuff that some, especially when you get to your smaller title companies in your rural areas, we got that up in our Paris office where we've got some smaller title companies up there. That it's so like one title company in the little town and they do virtually all the business. But they do things they want to do. That's the way they want to do them. And
Paris is particularly tough because there's only two of them, literally.
Yeah.
There's two of them there, they both know each other. They
Yeah.
don't like each other. So that makes it particularly tough.
Yeah. So,
And they know that. So if somebody sends me a deal for Paris and I have to negotiate for one of those two, they know that they're only one of the two. And they're gonna quote me a 90-day turnaround time.
yeah.
Painful. Yes, ma'am.
What happens, that I had that happen to me and I did not know who this title company was and I was a little leery. Everything went fine, but what would be the problem with something small like that? Could they miss something? Could they mess up the?
Well, no, I don't know that necessarily it'd be a problem with it being a small title company. We're all technically regulated by the same people. It's just because they're smaller, sometimes they take their time. They know that they're only shopping towns. They can kind of push you off. Customer service isn't always what you would hope it would be. There's not necessarily a problem with them. It's just not gonna be what you would get here.
Challenge is usually communication.
And they feel like they have a little more leeway because they're the only guys in town, you know.
And if the agent on the other side is one of their agents local that they do a lot of business with, that's who they're gonna cater to, in spite of the fact they're supposed to be this neutral third party. It's like builders title companies, nothing neutral about those. Should work through that process, so you have to be a little careful. I should work through it. So we've got some documents that you've QR'd up here. But we're talking about documents that people sign off on. There's some transactions that both the buyer and the seller sign off on. And there's some transactions, closings that only the buyer signs, some that the seller signs. I think it's a good idea for you to have a sense of it, because one of the things, and if it hasn't happened to you, it will, is that you'll be at closing, and even a good closer who is explaining the document that he's gonna slide across the table to the client. Client's gonna look at you because you're the one they've got the relationship with. They go at you and say, okay, we just signed that. Because they don't know, and they're trusting you. And so you ought to have a sense. I'm gonna make a blanket statement, and please don't correct me if I'm wrong, but there are no documents in a closing that don't have a purpose, don't have a reason for being there, don't have a requirement from someone, some entity says, yeah, if we're gonna close a loan, we've gotta have this. If we're gonna close cash, we've gotta have this. If we're gonna transfer a title, there's certain things, but there should not be any junk documents. Everything that's there is there for a reason. And the people of the title company should always know the reason. So if you've got a client who's very analytical, very anal, and go through the process, your client may look at some and say, what is that? Why do I have to sign that? Like we were talking about the owner's author, the owner's document, why do I have to prove who I am, kind of thing. But there's a reason for everything, and you need to feel comfortable with that. You need to feel confident. There's not any, now, by the way, that hasn't always been true. Back in the 60s, we had stuff where they just made stuff up. We had no idea what was going on. And one of the things, and I hate to be cynical about this, but it's absolutely true. Good local title company. I started out in Abilene. In Abilene, there were about 5 different title companies. And a couple of them had some slush funds. So their fees were a little different. Which is absolutely illegal, but it's gonna happen. I feel comfortable with the regulatory environment we're in now, but that really doesn't happen. Hopefully it doesn't happen, but
They get pretty deep into my pockets, so I can imagine they keep me up at night.
But the real key is all these things, all these documents have a reason, have a purpose. And you need to feel comfortable, one, that that's true. And second, you ought to have a sense of, yeah, here's why we have something like that. So, and you can just name, because we've got several things here, like in where they both sign off. Well, you can just talk about what it is.
So this is the stack that you guys put up in the QR code. The majority of these are just our title documents. We pulled out all the actual lender specific documents. We go to buyer only. These are title documents, and I'm happy to go over lender documents with you at any time. I don't mind doing that, but Bob and I were thinking that these are the ones that would be most important as an agent for you to be able to understand, right? Because what normally happens is when they sit down at closing and we go through these documents and we're signing them, it's not typically, is it okay for me to sign this? It's more typically, what's that fee? I don't remember that fee. And they're looking to you as an agent to be like, why am I paying that? And you have to say, 3 days ago, you signed an amendment giving the buyers a credit instead of making repairs, you're like, oh, yeah, yeah, yeah. You know, so just being aware of what we're gonna be looking at as we get into the closing, okay? So this first document that I always start with, and if you close with me, I close for the most part in the same order every single time, all right? And the more you close with me, the more boring it is, because I have the same scripts and I have the same jokes that aren't funny that I tell over and over. Okay, so I always start with this. So this is our statement, okay? And this is just a breakdown of both buyer and seller fees. Okay, I'm a little bit different. Some title companies will give you a statement that only has buyer side or only has seller side. It doesn't have both. If you tell me you don't want one side to see the other side, I can create that for you as well. But as a default, I'm going to present a statement that has both buyer and seller side. It seems to create an atmosphere with the least amount of confusion, right? It seems like it puts the sellers at ease, because a lot of times these fees, they don't feel like they should be paying for them. And I can say, well, look at the thing the buyer's paying for. It just makes it a lot easier. Another thing that it does for me is if I get a call, 2 years from now with a buyer looking for a document, right? I don't have to go back and say, well, I gotta have the seller's permission order to send that to you. I can send this because it's your document as well. And it was disclosed to all parties, okay? So I start with this document and we'll just go, I can go as deep as you want to go, but we'll just kind of do a quick rundown. The top part is going to have all the generic stuff regarding the total transaction. You have your sales price, you have your owners and option deposits, and you have your loan amount information, okay? The next section is going to go over your prorations. All right, so we're going to have all the different prorations for your taxes. If there's anything else for prorating, it's going to go listed in this particular section. After that, we're going to have, we're going to start, let's see here. We have a breakdown of some of the lender's fees, right? So you have points for reduce your interest rate, you have application fees, appraisal fees, credit reports, so on and so forth. These are all the different fees for vendors that we're paying out. Below that, we have loan specific charges, okay? So you typically don't see anything in here in regards to the seller, with the exception of the tax cert fee, which the seller pays for, but it's a requirement by the lender. So you see that $47 fee there, okay? Below that, you have your impounds, which the lender gives us. This is the creation of your impound account for escrows. If they're not escrowing taxes or homeowners insurance, that section will not be there. Below that, we have the title charges. So these are all the charges that my company is responsible for. Please know that a lot of those are promulgated by the state of Texas. I cannot control those. So your policy fees, your endorsements, those are all promulgated. Okay, so they tell us exactly what those are based on the loan amount or the sales price of the property. Below that, if there's any kind of a commission that's paid out to the broker from the buyer, that's going to be listed there. Below that, we have the actual recording charges. So what you're going to see is you're going to see the buyer paying for the deed of trust to be recorded. You have the seller paying for the warranty deed, transferring the property into the buyer's name. And if there's any additional documentation that's required that has to be recorded with the state, that'll be listed there as well. And it'll be obviously assigned to whoever's responsible for that particular fee. So if there's a disclosure for a mud or a PID that has to be signed off on, I have to have both parties sign that. I have to have it recorded. I'll usually charge that to the buyer because it's something that the buyer has to pay for. Warranty deed be charged to the seller because the seller's responsible for transferring the title. If there's a dead person on title and I have a probate or have something that I need to record in order to clear title for the seller, that's all going to be on the left-hand side to record that. Okay, so it's all just pertinent to the individual responsible for it. Below that, we get into miscellaneous fees. All right, so that's where your survey fees would be. If you have any kind of an admin fee that you're charging for your TC, and we have our agent fees is what I call them, agent commissions, agent fees.
So while you mentioned survey, let's talk a little bit about the survey.
Please.
So, it's one situation with 61 existing survey, but in 62 and 63, we talk about new survey, which is who's going to pay for it. But even if the seller's going to pay for it, when you order up a survey, that survey is going to be in the name of the buyer. Okay, as you go through the process. So do you have like a pool of surveyors? Because the agents and the buyer and seller, none of those people typically have, well, we want to use this survey shop. So how do you go through that process of ordering a survey?
We have 3 surveyors that we use primarily, and really and truly it's 2 that we go back and forth with, and the 3rd that we have on standby just in case. And that's Old Town, Burns, and CBG, I believe, is the third one. My ladies over here would know it. But we will alternate back and forth between the top two. And that's gonna be based on who's giving us the best price, number one, for our clients, and number two is the best turnaround time. And those always go hand in hand. Right, if the surveyor is out 2 months, your price is gonna be $1,200, and if the surveyor is out 3 days, it's gonna be $400 for a survey. Right, so they always go hand in hand, and we're looking for the best deal that we can get for that buyer and seller. We don't play favorites on that.
When you get that new survey, and that's part of the package, and what happens to that survey? To go to the buyer or to the lender? Do they look at it? Shows up in the closing docs?
We get a copy of that survey, and it's immediately sent out to both buyer and seller. At the same time, we're sending buyer and seller, we're sending it to our underwriter to review and approve to make sure there's no mistakes. Make sure that the legal actually closes and the surveyor didn't make any errors, clerical errors in the legal description itself. But once the underwriter reviews it, they will approve it. We'll send it back out saying this has been approved and it's clear for closing. Then we'll then go into Schedule C for title commitment, and the very last item on your Schedule C is that the survey dated by so-and-so surveyors has now been approved. So your Schedule C will tell you whether or not your survey's been approved for closing.
Every new survey should be fine. We might have copyright issues on existing surveys, because the seller may not have the authority to use that survey to the next buyer. But on a new survey, it's not a problem. The surveyor made it for that buyer, so there's not a copyright issue as you work through it. One of the many reasons why we really like to always recommend to our client, to our buyer, to get a new survey. Just who pays for it, it's just a negotiated item. Should work through that.
We have a situation right now where we had a survey that we ordered for a property, I forget the county, it's not far from Baylor, down in Waco. And we got a survey that came back, brand new survey, sent it out to all parties, sent it to underwriter. Underwriter declined it, said we can't use it because it has to have a sentence on there somewhere on the face that says that this property is free and clear of all encroachments. Surveyor made a reply back and said, I haven't used that verbiage since 2011, and I will not put that verbiage on the face of your survey. So we had to go back and forth and try to figure out the best way to handle that. But at one point, we had to go say, hey, we sent the survey out. Survey is not approved. We're still trying to figure out exactly what we're doing. Makes us look bad because we picked the surveyors, right? They'll come to me and say, I got a property in Waco that I need to close, order a survey. You're probably not going to give me a surveyor, right? We don't use surveyors down there very often. So we immediately get off the phone book and start calling. What's turnaround time? What's the best price, right? We try to find the best price, the best turnaround time for our clients. And we get it ordered, and it came back and underwriter didn't like it, and surveyor said, I'm not gonna do what your underwriter wants. Now we got somebody wanting payment and somebody that doesn't have a survey, right? So that's just kind of some of the stuff that we have to deal with behind.
What was
the
the
scenes.
surveyor's rationale for not allowing that?
He just said that nobody requires it. He thought we were being ridiculous. And I go tell my underwriting attorneys that, and they say, well, we can be whatever we want to be. If you want us to insure the property, you're under oath otherwise. So we ended up going back and forth, and the surveyor finally acquiesced to do what we needed him to do, but as for a little bit there, it got real frustrating. And I think the surveyor finally understood that, you know, we didn't get what we needed from him. He wasn't gonna get paid on it despite the work that he's done. He still doesn't provide us with a survey that was approved. But the rest, we couldn't use it.
Yeah,
So-
and I could understand his rationale at some level. He feels like he was warranting something. He was, you know, which he wasn't willing to do. But it does show that in different areas, there are different customs of how things are done. And underwriters should adjust to that.
Absolutely. They should.
Yeah.
They should. But a lot of that comes back down to how much business do you do with that particular underwriter?
Sure.
Have you been nice to them? Have they been nice to you? Did you get an argument with them over the last exception they put on your policy, right? They have bad days and good days too,
Sure.
right? So you have to figure out, you know, a way to work with these individuals, and underwriters are just like title companies, you know. We have certain underwriters, you know, there may be only one underwriter that covers a certain county. You know, and you have to go and you play nice if you're gonna be in that county, and they know that, you know. So we deal with all kinds of politics on our side too.
It's not like real estate agent because we're all really easy to get along with. Right, Donna?
Yes. Very
One
excited
hundred
to drive.
percent.
I'm saying,
I was like, why you calling me out?
yeah. Because she is, she's good people. Do you agree with that? Do you agree with that?
100%.
Okay.
There you go. Okay, so that's my statement, all right? But the most important part is it has the bottom line. Right, and it'll be on page 2 or page 3 at the bottom, right? It goes through and it says how much the seller is getting or how much the buyer needs to bring to closing. And then we have it executed by all parties, okay?
Everybody signs off on that.
I have everybody sign off on that, okay? Next, I will bring out the closing disclosure that's provided to me by the lender. If it's the seller, it's provided by the lender. If it's the buyer, it's provided by us. This is the document that your lender, your buyer's lender requires before they will disperse on the file, okay? This is the new closing disclosure that's required by law, right? And I will tell you exactly what I do. I pull this out and I say, this is a closing disclosure that is required for the lender in order for them to disperse on the file. This is identical to the statement that I just went over with you line by line, okay? And if you will notice at the bottom of page 2, the statement we just went over, it shows that the buyer is to bring $100,000, $100,764.01 to closing. And I'll show them the closing disclosure. If you notice at the bottom, your closing disclosure shows cash to close, $100,764.01. You're welcome to review it, but it matches identical to the statement we just went over. All right. 1 out of every 10 engineers will go through and they'll read it word for word. But 9 times,
Hey, that's not funny.
99 times out of 100, they're gonna sign it. So there's your closing disclosure. At that point in time, I have a signed closing disclosure and I have a signed settlement statement sitting in front of them. Then I will pull out my third document. It's always my third document and say, this is our T-64. This is a Texas required disclosure. This goes over the exact same figures that we went over on the first 2 documents, right? Texas requires this because you're not always required to disclose certain fees to a buyer or to a seller. But there are a few fees that Texas requires to be disclosed to both sides. So that's the reason for the T-64. They say, let's make a new form, okay? I've already went over all those fees with them. So I just show them, here's the policy we already talked about. Here's the endorsements we already talked about. Here's the recording fees we already talked about. Please sign. Okay, at that point, they're like, I wish this guy would shut up. All right. We're just going through stuff that they've already went through again. The next document would be your tax certificate. Now, I don't have a tax certificate in here. This is what your tax certificate looks like in my stack, right? But the tax certificate will actually go through and it'll show the list of taxes right now. It'll show 2022. It'll show proposed for 2023. It'll show any exemptions that are currently listed on the property. And it'll also have contact info for the HOA if there is an HOA. It also breaks down the entities that collect the taxes, right? And then it also shows who collects for that entity, if it's all payable to a county or if some go to different cities, so on and so forth. So I show them all that information, okay? I show them the taxes that we're using for proration and where I got that off of the tax certificate. And then I pull out our tax proration agreement. Say this is our tax proration agreement that says we agree to prorate taxes between buyer and seller, all right? And then depending upon the time of year, I tell them how we get those figures, how those figures are calculated. And then I pull up page 2 that shows the top dollar figure that we use for the prorations that we've already went over twice. Right? Where we found that off on the tax, where we found that off of on the tax certificate. Did I say that right?
Yep.
On the tax certificate. And go through and just kind of explain this document to them, how it protects them as both buyer and seller, right? In case the prorations are not 100% correct. All right. They sign that. The next step.
You want to touch on the landmine that we're dealing with? Or about to deal with?
I do,
Exploration?
but that may be the rest of the whole meeting. Do you want to wait to that at the end?
We can do that at the very end.
Okay. So after that, I get into my limited power of attorney. Okay. This is a limited power of attorney that is for the title company, only for me. It says in big black letters here, bold black letters, it says this is for typographical errors. All right. And I tell them exactly if there's an I that wasn't dotted or T that wasn't crossed in your closing paperwork, this allows me to make that correction for you. So you don't have to come back and see me again. Next, we will have a marital status affidavit. So now, we use Fidelity 99% of the time just because they're the biggest in the world, right? Fidelity sent out a new requirement that says we have to have a marital status affidavit on all closings now. They don't want to look at it, they don't want to see it unless a claim arises, all right? The reason they do this is because other states are much more forward-thinking in recognizing marital unions. Texas, we have to recognize them as well for the underwriters, but there's a lot of gray area, as you guys can imagine, in homestead rights. Who has homestead rights to the property, dowry rights, so on and so forth, based on marital status, based on marital unions. So now we have to have one of these filled out for every file that we have. Nobody sees it, it just stays in our documentation unless there's a claim that arises. Okay. Next one, we're into, and really and truly, I usually have this as the very last page of the closing. But for this particular sake, since we don't have lender documents, it'll be next. This is our ABA. Affiliated Business Arrangement Disclosure. But I don't have to show this to you guys because you guys are already having it signed. Whenever you get a listing agreement signed, right? This just says that trust title is partially owned by individuals here at Keller Williams. We are required by TDI to disclose that ownership along with our set fees, which is my $500 escrow fee, a $47 tax cert fee. Those will not change for closing, and the breakdown of TDI insurance rates. I cannot tell you guys enough. You need to have this signed. If you're going to use this for title, which we really, really hope you will, you need to have this signed up front. Because there are a few brokers out there that are savvy enough to know that this has to be disclosed up front. And if it's not disclosed, they can back out of the contract without it. One of those being Miss Macaluso.
Yeah.
Because she owns a title company. So she's aware that that's.
Coldwell Banker does.
Yes. So she was where they had to be signed, and we had one that got sideways, and she called and said, well, we'll just tell our clients to back out if this doesn't work out because y'all didn't have the ABA signed. So just make sure you guys disclose that, have it signed up front. All right, perfect. Buyer specific documents. Next document we're going to get into, so this would be on the buyer side only closing, okay? Those were all buyer and seller documents. These are the buyer side only documents we'll go through. So this is my FERPA document. This is my Foreign Investment Real Property Tax Act. When I tell them basically, this is just saying that if the seller is a non-resident alien, I'll be pulling 15% of the sales price of the property, sending it directly to the IRS. This has to be disclosed to you whether the seller is a US citizen or not. Feel free to review and let me know if you have any questions. Got it. Next is our errors and omissions. Okay, if there is a lender involved, I'll have this errors and omissions document in there. We do this on behalf of the lender. Just basically says that it gives them limited power of attorney to fix any clerical errors. And it also sets out that if there's an error in the documentation that you agree to work with your lender in order to get those documents approved. Lenders also have their own compliance agreement they make you sign. But we put that in there just in case. Okay, this is essentially a fancy power of attorney on behalf of the lender. Let's see here. We have privacy policy next, and what we do with your personal information, we don't sell it. When we get into my seller specific documents, seller's package is always very small. The bulk of the seller's package has to do with their tax implications. So the first you'll see here is our certification. We even call this officially. Certification for information on reporting of the exchange of a principal residence, right? I use this in my file to determine whether or not capital gains may or may not apply, okay? All the title companies have this document. They all look a little bit differently, okay? But we're basically trying to go through and assess if capital gains applies or not, right? And I will go through and help fill this out, help your sellers fill this out to the best of my ability without answering it for them, all right? The important thing to know in this particular document is that if one answer is false, the whole page is false, right? So I will immediately look at this whenever we get into closing, right? And if it's an individual and the sales price of the property is more than 250,000, I'll mark false, I'll have them sign it, and get rid of it. If it's more than $500,000 and they're married and they're filing jointly, I will mark false and I'll get rid of it. I won't ask them a single question, okay? Just so you know, if you see that. But that's what we're looking for. We're trying to figure out whether or not capital gains applies. They ask questions about whether or not they purchased the property with 1031 exchange. It asks if it was a principal residence for 2 out of the last 5 years. It asks if they sold or exchanged another principal residence within the last 2 years. So on and so forth. So it's just kind of just some leading questions to figure out whether or not there's capital gains tax that applies. Next is going to be my 1099 info sheet. All right. This tells me whether or not, first of all, we have your social security number on here, right, that you use for filing your taxes. It tells me whether or not they want an individual tax returner if they're filing taxes jointly. It asks me if they're single or married. And it asks me for a good forwarding address that I can use if I need to send documents to next spring. Okay, just an information sheet for us. Then we go into the actual 1099. This is what we will have them sign, and this is what they will actually take to the CPA in the spring, okay? Just goes through, and we essentially have them verify that their last four of their social is correct. And then we will have the sales price of the property listed in the 1099, okay? And we will either have it split 50-50 for husband and wife, or we can have one that has the full sales price and one that has zero. It doesn't matter as long as they both equal up to the sales price. Or more recently, we were able to amend this document. Now, a lot of times I'll just have the sales price and I'll have them both signed. It's fine, as long as we all get to the same location at the end of the trip. Next. The T47, I will tell them. You already filled one of these out for your listing agent at the beginning of the transaction. I just need another wedding copy from my file that I notarize that says there have still been no changes to the property since we had our last survey in T47. Okay, so again, it's just refilling the same things we already have.
And you only use the T47 in what, one case? Existing survey.
In your existing survey.
Don't ever have to have a new survey, just existing. Which the only reason you're using an existing survey is your client didn't listen to you. You get to, well, now, Bob and I have talked, and you really should get a new survey. When you're paying $20,000 more than list price, you're arguing about a $500 survey. Jeez.
It will.
Yes, it will.
The next is our owner's affidavit. I had a client recently tell me that this must be the good person affidavit because the questions they all sound like they're questioning their credibility, but it asks whether or not there's any other contracts for sale of the same property. It asks if there's anybody else in possession of the property, if there's any outstanding judgments, if there's any unpaid or delinquent assessments, or if there's any judgments on the property, if there's any zoning violations, if there's any limitations of access from public roadways. So I was explaining this to a client and passed it in front of me. He goes, I get it. I'm a good person. Just give it to me, I'll sign it. So it's called the good person affidavit.
The challenge we have with this, and one of the things this picks up on, is when you've got a seller whose previous contract fell apart, they didn't resolve the earnest money, so he took the contract to another title company to sell it to another buyer. And here he has to own up to the fact that, oh yeah, I've got this other contract that it fell apart, but it hadn't been resolved because there's money issues still there. They can't take it to the same title company because the same title company won't close it. That's why they go to another one. But this thing here, they have to own up to the fact, well, yeah, technically, I guess I do have another contract.
What they normally do is they just sign it. And then I get a call from an underwriter.
I see that, but that's okay. We can't protect against the big lie.
That's right.
By doing the paperwork, the title company, as well as we've got to rely on the information. It's like a lender has to rely on the information and verify it over the process, but they have to, if they've done this, they at least have that documentation. If they don't do it, then they're in trouble.
That's right. All right, next I have a seller info sheet. Just give me where you're moving to. I need a good forwarding address so I can get a hold of you. Any reporting overages, I need an address to send those to. Any money that comes back to me accidentally from a lender for an escrow account, I need to know where to send it to. So this is just a contact sheet is all it is. And last but not least, proceeds authorization. How do you want to receive your money? You want to check? You want to wire? You want to check? Or do you want me to mail it to you? Do you want to pick it up? Do you want to wire? I need your bank account information. And then I need all sellers to sign it. Everybody has to sign it. Now, there's one other document that's not in here. If there is a scenario where we have a divorce, right? The divorce decree splits out and says that 60% goes to this person, 40% goes to this person. Or any time where the sellers are not getting along, or there could be potential for any ambiguity anywhere in the transaction, I'll have another disbursement authorization that says the proceeds for this transaction are $10. And below that, it says Johnny's getting $6 and Susie's getting $4. And breaks it all down in black and white, and they both sign that. Right, so nobody can come back to us and say, this guy got more money than I'm supposed to get, or this is not fair. You saw it, you're aware, you signed it, this is all per the divorce decree, or per the instructions that you gave us prior to closing.
Okay, so while we're talking about proceeds,
Yes.
let's talk about commissions.
Uh-oh.
One of the things that I don't ever want to have happen. If it happens to you, I want you to call me so I can talk to the title company. I don't want you to have to ask for your commission. The title company needs to say to you, okay, here's your commission, how do you want it? And you'll have a CDA from us. But even with a CDA, sometimes we'll mail it to you, or we'll say, so I need to know what your process is to make sure our agents get paid and they know how they're gonna get paid, when they get paid.
So we will ask for CDA if we don't have a CDA. All right, and once we have that CDA, what usually customs with that is the exact same time we will ask you how you like to receive your money. If it's an agent that's worked with us before, we will take your writing instructions with your permission. We will save those. We just have those on file, and we know going forward, all of these will be wired to you. If it's an agent that only wants a check, we do have some of those only want checks. Then we know, we make notes from that, and we cut them a check each time. So to answer your question, that when we get that CDA, it prompts us to ask, how would you like to receive your money? But I will say, you would be surprised, not necessarily with this office, but you'd be surprised how many agents don't give us CDAs until 2 or 3 days after closing. Because their brokerage or whoever is just that far behind, didn't get them to us, or they don't
So
turn
how
it
do you
in.
know what to pay? Without a CDA, how do you know
We don't pay.
you don't pay?
I don't pay. I do not pay unless I have a CDA. Now, if it comes to me and they say, we don't have a CDA, we're not getting you a CDA, and we've asked for it and asked for it and asked for it, we'll eventually bundle up that check and send it directly to the broker, and the broker's responsible for dispersing those funds. It's the broker's money anyway.
Yeah, because all compensation has to be through the broker or authorized by the broker.
Right.
So, because CDA is certainly okay with, if that's the arrangement we have where the title company to cut you a check and cut us a check, or whatever. So I just, you've done the work, you need to get paid. You don't need to finish that closing and worry about cheating. You got that Mercedes payment coming up, so you need to really say, okay, where's my money? So
Now, I usually don't have an issue with agents telling me how they want to get paid. It usually just kind of happens
Because
organically.
that's the only surprise. I want to see it closing. You're going to get more money than you expected. I'm okay with it. Other surprises, we don't have. So questions you have for Austin, because we've got another thing that we're going to talk about, and we'll get some paperwork in the back before we get into the contracts and issues there. So great explanation. Does this help you have a sense of kind of how things work so that you know what to do for your client, seller and or buyer? Yes, ma'am. Question?
Who pays in today's market, who pays title policy?
Well,
You tell me.
No, I realize that, but
it's
I just wanted to ask, Bob says whoever needs it pays for it.
okay, now and it's a good question. And this shows the evolution of the contracts over many versions. A long time ago, well, actually, 5 versions back, there were not 2 boxes in 6A. The seller automatically paid the title policy.
Okay.
You had to make a change in the language for some of these special provisions for the buyer to pay. It was automatic with the seller's obligation. And then the market changed enough that we finally moved to, and this only happened, I guess, 3 times back, where they've got 2 boxes. So anytime you've got 2 boxes for anything in the contract, your mindset is that's a negotiable item. And so the agent needs to look at what's going on in the transaction. And you've got to deal with your buyer who's paying $20,000 more than the list price, and is fussing about $3,000 for the title policy. I mean, so that's part of your negotiation. Now, we do understand the mindset of a lot of listing agents that they're looking for a good, clean offer. And there's certain targets, there's certain things they look at. One, who's gonna pay the title policy? What's the survey issue? What about the HOA? What are the number in the HOA? They're looking at certain types of things. And that's one of them. And so that's a totally negotiated item. Anytime you've got a choice of the contract, that's a negotiated item. And it's your job going through the process to help you advise your client. Here's something you need to work on. Here's something you need to negotiate. Because you need to, as you work through the process, we tend to pull together, and maybe this is kind of where y'all are going with this, who pays for it and who chooses.
Well, that was my next question.
So, this rolls back to RESPA, Section 9 of RESPA, which says that a seller cannot require the buyer to purchase from a particular provider. Which means the seller cannot say to the buyer, if you're going to pay for the title policy, you can choose, or if you're going to have me, the seller, pay for it. So it says, well, then I get to choose. Here's our policy. Here's Bob's policy. Here's the right thing you need to understand. We don't care who pays for it. That's a negotiated money item.
Okay.
We care that the title company is a good local retail title company. Don't ever let the choice of the title company get in the way of the deal. If a seller's got preferred title company, and as long as you get one of the good retail title companies, if it's a little fee attorney office, I worry about those. And I do, because not just the communication, not just service, small, which are typically an attorney and a girl Friday. And one of the problems they've got is getting documents to the county, recording documents. Every once in a while, when you get one that's really down the deep hole, we worry about their checks. Because here you've got a seller who's going to convey title, and he's looking at a $400,000 check from this attorney who's got, he's got in his executive suite somewhere, he's got his little title company. Those make me nervous. But otherwise, any of the major good, Trust Title, Chicago Title, all the good major ones, we don't care. I mean, we truly don't care. And whatever it is, you work through it. But we understand the RESPA rule, and that doesn't matter. You got to look at who pays for it. It's totally a negotiated item. It's like, what's the sales price going to be? What are any of the other costs going to be? Those are all negotiated items. It's negotiated money items. Choice of the title company is a service choice. And remember, if you're ever in a multiple offer situation and the seller has, the listing agent indicated, here's the title company we'd like to close with. Your buyer says, well, I'm going to pay for the title policy to make this a good offer. I'll choose. Well, they get to choose the title company. The seller gets to choose not to accept their offer. So your buyer gets the title company, they just don't get a contract. So don't let it ever get in the way. Does that help with that?
Yes, very much so.
That was my one question. So buyer can also choose the title company.
What do you mean?
Buyer can choose a title company, like it's already in the MLS by the seller.
Yeah,
So if buyer chooses another title company, they can choose that. That's also negotiated with the buyer and seller.
sure. Buyer, first of all, we negotiate the price.
Yes.
And second, we negotiate the title company itself. And you got to remember, seller is not obligated to accept your buyer's offer. So when we say the buyer is choosing the title company, the buyer just made an offer and they're negotiating a point in the offer. Or saying, I'll pay you $410,000. And by the way, here's the closing date. And by the way, I'll pay the title policy. By the way, here's the title company. Those are negotiated items. So saying that a buyer or seller get to choose doesn't mean anything. Because until the seller accepts a buyer's offer and we have a contract, that doesn't count. It's just, you have to kind of work through that. But it's just, it's negotiated item. Yes, sir?
Are y'all calculating for the first, 9-10 months of the year, prorated taxes based on the previous year? And if in certain situations, we know it's going to be super different, if both parties agree, we prorate on a chosen number.
If both parties agree, I'll prorate on whatever you want.
For instance, like if you had one that was, say, the new construction or something, and say it's on the tax rolls for last year at $300K, but now it's a $1.7 million house, And so in the tax assessment proposals have come out and you know that it's gonna go up, significantly. I just didn't know what y'all's stance on it, 'cause that's a difficult deal after the first year, like.
Yeah.
So-and-so calls that I paid too much, the other person's not answering the phone, you know what I'm saying?
Yeah, we just had one recently where it was new construction and the buyer came to us concerned about that. Of course, obviously the builder's not gonna bring that concern out, but the buyer came to us concerned. And we offered to go to the seller and say, hey, here's a concern that your buyer has. Are you okay if we amend the prorations? So what we ended up doing, the seller was okay with it. What we ended up doing is we ended up taking the appraised value of the property and multiplying that times the 2022 tax rate and use that for the prorations. And what the builder essentially said is absolutely, I'll do that. And I'm gonna tell them that I'm doing the prorations based on what you want me to do. Don't come see me in October if something else happens. That's what I can tell them that, but there's nothing precluding them from coming to see you if that's changed.
But what we also see, and we see this more with institutional sellers, is they've got an addendum that says proration closing is final.
Yep.
But you won't get to come back a couple months later and try to do something.
Yep.
Done, deal's over.
Yeah, and there's a paragraph in these closing documents that actually says that, it says that the prorations, if there are prorations, and there's another one that says taxes are 100% up to buyer, taxes are 100% up to seller, so there's different ways that we can manipulate that particular addendum to make sure that we're doing exactly what they're asking us to do. But yeah, absolutely, that's a good question.
So while trouble has gone ahead and kind of brought up the point, you have time for us to talk quickly about what's going to happen November 7th.
Yeah, so July 22nd, Texas approved an $18 billion tax cut. As part of that tax cut, $12 billion is going to go towards a credit of school taxes, right? So what's happening is here, Texas approved it, but once Texas approves it, it then has to go up to DC to actually be approved, okay? And that vote is on November 7th. When Texas approved it, they approved it effective immediately. So once it goes up to DC and it's voted on November 7th, if it's approved November 7th, it's effective immediately for 2023, January 1. All right, so we have 11 months that we have to figure out how to handle from closings that we've already had, right? So luckily, the prorations portion of the 1 to 4 lives on past the date of the contract, right? So all those prorations are there taken care of. The tax proration agreement says that if for some reason those prorations change, buyer and seller, who are the parties to the contract, agree to meet afterwards and to make the other party whole. Okay. So what this means for you guys is you need to be aware that part of this bill being approved was a requirement for the assessor collector for each county to send out tax bills in October that show the current tax bill and what the bill will be if Prop 7 is approved November 7th. Right? So that means all your clients are going to get a tax bill here next month that's going to have 2 different tax figures on it that they're required to pay. Theoretically, right? So you guys are going to be getting calls. What is this? What does it mean? And you guys are going to be able to respond to them and tell them exactly what that means. So what's going to happen is if we go through and everybody votes and they approve that tax bill, all right, it's going to take your homestead exemption from $40,000 to $100,000 effective January 1. And it's going to give them a big cut on the school taxes that they currently pay. An example that I was given is, let's see here, a $350,000 house could theoretically have a reduction of $1,300 a year on their taxes, right? The $350,000 house. I don't know that we've done many of those this year. They've all been 3 or 4 times that many. So just kind of keep that in mind. It's a significant tax cut, right? So just be ready when you get those calls. What does this mean? What does it look like? Just tell them. If this is approved, this is your tax bill that you're going to need to pay, which will be significantly lower. If it's not approved, this is what your tax bill will be. But it's essentially an advertisement for get out and vote, right? Get out and vote and approve this. There's probably a 99% chance that this is going to pass. On the webinar that I was on discussing this, I said they've never seen a tax rate fail, right? So the chances are it's going to go through. Yeah. So, but that opens us up as a title company in a completely different, scenario. Because now we're gonna have sellers saying, no, I want to prorate on this, and buyers saying, no, I want credit for prorations on this, okay? So as we're, as we're talking through this, just know that if I do a proration on the theoretical tax decrease, right? And I say, all right, we're gonna prorate you for $10 based on what your taxes would be if Prop 4 is approved, right? And then it doesn't get approved. The policy that I've given you says that all your taxes are paid in full, right? So that opens me up for a claim on every one of the transactions that I've already closed. So just know, I'm gonna go through and I'm gonna prorate taxes based on the full 2023 tax bill without that being approved, right? And you will have the tax proration agreement that says if for some reason that changes, seller could technically ask the buyer for a credit back. That is the only way that I can keep a hand with it.
Yes, yeah, it's not.
That could be-
that's all of them.
yeah. So you need to prepare your client. We've had this for a long time, where you, after the fact, you check.
Yeah.
And most time, nothing happens. This is gonna be significant.
This is gonna be significant. Now, here's what we are going to do, and Bob, we're talking about this earlier. Mr. Sam Carter, he's coming to teach a class for us here on the 20th. He's our attorney. He's fantastic. I hope all y'all can come see that. We are gonna have a clause prepared, written by attorney that we can provide for you guys. That says buyer and seller agree to prorate on whatever they agree on, and I will be happy to use that as a bilateral agreement between buyer and seller. We can put that special revisions and we can use that, to help clarify kind of the way we're handling those tax prorations. But the bottom line is, there is nothing in any of the paragraphs, so on this webinar that I went through, we went through the Trek 1 to 4 proration contract. We went through the Realtors Commercial Contract, and we went through the State Bar of Texas Real Estate Forms Manual. And none of those have any verbiage or anything that spells out what you do whenever there's a tax change, right? So nobody knows exactly what to do or how to handle the prorations as it's going through. So we're all just trying to kind of tiptoe through it the best we can. We're trying to make sure that we keep buyer and seller happy, and we're trying to mitigate any claims that this could potentially cause. So
It's October.
October first.
First, okay, so.
Yeah, but that's if it's approved on November 7th.
And then it goes to the 7th.
That's right.
So 37-day window, basically.
if tax bills come out like they're supposed to, right?
Yeah.
So technically, we're supposed to quit issuing our not yet doing payable October 1.
Mhm.
But like Harrison County, I don't think they came out with taxes until like November 15th last year. So it just depends on the county. Dallas County is always a little bit behind. Collin County will be. Yeah. Yes.
Okay, so once tax bills come out, let's say it comes out on October 1st. You have closing after October 1st, you all usually pay the tax in full to the entities. Right?
Yes,
Okay.
well. If they're not, yes, go ahead. I can go deep on that, but
So my
yes.
question would be, if you got two bills, two potential deals, but you're actually not, you're prorating, but you're not passing money back and forth between the buyer and the seller like you normally do any other time of year. You're gonna pay that bill, but which bill are you gonna pay? If you pay the higher one, then how
Yeah.
is that money get back to,
Yeah, you have to fight for it?
see what I'm saying?
I will tell you guys a little secret. Whenever I collect money to pay a tax bill, I usually hold that for at least 30 days at my office. Taxes don't become delinquent until February, right? So there's no additional per diem. So if I collect money to pay a tax bill for you guys, I'm gonna hold that for at least 30 days, making sure that your payoff has been received. Your seller's payoff has been paid in full, and they haven't used any portion of their escrow impounds in order to pay, in order to pay that down. I'm making sure there's no shortages, is essentially what I'm doing. So in this particular year, we will probably hold those payouts for 45 days. Just to make sure, that's a good question. So all the more reason why that seller info sheet needs to be correct, because I'm probably gonna get a check back from us. Because I will collect the higher figure until Prop 4, what did I say? Prop 7 is approved. Yeah, so it is,
What if we have a closing this month,
we have closing this month and it's still business as usual.
2022 tax?
2022 taxes is what I use, and it's what everybody else uses as far as I'm aware of. I'll use 2022 taxes because that's all I officially have unless I have a bilateral agreement between buyer and seller for something else, which is very common as we get this far into the year. Yeah. So just know that I'm gonna be working with our attorney to try to have some kind of a universal language that we can use, that you guys can put in special provisions that addresses that tax proration, because it's gonna be a big deal. It really is.
So we can, the exam on November 2nd, date would be what, because I have a closing in October 23rd. What would happen to that?
So October 23rd, I am going to collect and prorate taxes based on the 2023 full tax bill.
2023,
Yes.
Because you'll have theoretically the tax certificate by then.
okay.
It would have resolved the tax roll.
It will be done, okay.
Yes. Problem you're gonna run into is your seller's gonna get that tax bill that says, if this is approved, this is my tax rate. And they're gonna be frustrated that we're prorating at a much higher dollar figure. So you guys here in this room are the few ones that'll be prepared and be ready to talk to your clients about why we're doing that.
But you have to at that point in time because it hadn't happened yet.
Yes.
You can't do it well, just in case. Yes, ma'am.
I just heard you say it's going to be a clause for special provisions. I know Bob is very,
It was done by an attorney,
So it's-
an attorney with the title company.
and so instead of it just being an agreement at closing, it's for those short amount of days. It's up to us to predetermine that before we even get to title, is what I hear you saying.
I'd recommend that you just get that negotiation out of the way as you're negotiating the contract.
That's, okay.
That way it's just done and you
Yep.
don't have to worry about it.
And like I said, I know it's short, so it's just.
Yeah.
It's just.
It's very short. We just wanna. Buy your works. I think it's gonna be a big deal. Figuring that people realize. Sorry. Sam Carter. He's the attorney that we use for best practices. We use him for if y'all, had a deed prep for your closings, it can.
So he's gonna do a little deep on.
Well, he will if I ask him to, but he's primarily coming to teach about probate. What happens if your seller dies, there's dead personal title, what's the process for getting that cleaned up? So
So is he.
That's where we have the most-
After debt, or
we have a lot of dead people on time.
is he working on the clause to give to our brokerage to be able to kind of be prepared
Yes,
with that? Okay.
yes.
What time is it gonna be on the 20th?
1 to 2,
Okay.
1 to 2
Is there
is,
food involved?
no, but if you're here, there'll be Coke here. No, I think the actual title of Sam's very clever. I think it's Sam Carter's probate class that everybody's dying to attend.
See, I've met Sam Carter. He's a good guy. He hasn't bought my lunch yet.
He's offered it. He's offered
We'll
it.
get there.
Now, the neat thing about Sam is his primary role, what he does from 9 to 5 is he practices real estate litigation. Like he's going to court and he's working all these. So he's very good about what does the contract say? And here's what I actually see when it goes to court. The other good thing about Sam is he actually owns 4, maybe 5 title companies. He owns a Commonwealth, he owns a lawyer's office, he owns these different fee offices. He's got one in Maybank, one in Rockwall, he's got 2 or 3 others. So he's really, really sharp about what does the contract say and what's really applicable. Yeah, he's really good for real world questions. So I love calling him and saying, hey, I need a best practices answer.
So
So,
I know that Austin has to go, but any other final question? Because we're gonna go into my part of this thing. We'll get to paperwork in the
I
back.
have a
So
question, like you said, $350,000, what was the number for reduction, tax?
13,
You said 13.
1,300.
Cutting from it.
Yeah. Yeah, $350,000, you can see a $350,000 home, valued at $350,000, we'll see a reduction in school taxes of about $1,300 a year. Yeah, 2 years.
Yeah.
That's for kids.
Okay, let's give him a hand. There should be, is there paperwork back there that has the contract, the highlighted version? Is that the highlighted version? Yes. Okay. Thank you, sir. Would you call me? Thank you, sir. Really appreciate it. I'll accept that one.
Are we still on? Have you heard back from?
No. Which pay, whatever it is.
Bueller, anyone? Bueller?
It's funny.
Yeah, sorry. You should. Hey, sure. Yeah.
That thing I called you about today, we've got a 3:30 call with a lender, so if I get up and leave, I just didn't want you to think I was being.
Most people, okay, great. Yeah, good, for reaching out to us. Good for reaching out to us.
Yeah.
Okay, everybody got documents? Hello, Zoomer, you there? You got documents too? We're looking at. Shh. Stacy and Donnie through their meeting.
What did you say?
Telling you.
I'm so sorry. Want me to leave?
No, I do not. I appreciate you being here. Thank you. There are some things. In the contract that even though they've been here since February, we've used them since February. We need to remind ourselves of, because we know one of them is gonna be a work in progress and we don't know if we're gonna finally get resolved. But on the first page of the contract, paragraph 3, where we have language in there that talks about the cash deal. The concept there is that if somebody is really truly doing a cash deal, that there are no borrowed funds. Now, we understand that we're still having trouble defining borrowed funds. You know, it's somehow your 401k or line of credit your bank, I mean, all kinds of stuff. But the consistent problem we have are with investors with hard money loans for treating it like cash. And it's clearly not. In fact, in the third-party financing addendum, we have a new paragraph G where you've got a place, and the only place we've ever had in the contract, place for the name of the lender, and that's for hard money loans. But if the buyer is using hard money loan, he's got to put the name of that lender in here, that information in there. Because it's clearly borrowed funds, it's not a cash transaction, or we're seeing investor buyers treat it like cash. So you need to be aware that, which means that they'll put 3A and 3C, same number, they won't use the third-party financing at all, because they think it's cash. So as listening, you need to pay attention to that. You need to ask for really, good proof of funds and ask the questions. And most of the time, investors will loan back, well, technically, if the property is the total collateral for the deal, it's not a big deal, but it is. Because the seller's saying no. The question that a seller should always ask a buyer, a cash buyer, you're gonna pay $400,000 in my cash, we're gonna close in 2 weeks. I wanna know where the $400,000 is right now. I wanna know that it's in a financial institution in this country right now. We all know that other countries have rules about how much you can transfer on a regular basis, so we need to know right now. Otherwise, we don't truly see it as a cash transaction. So we just need to be aware of that kind of situation. In paragraph 4, and it's not highlighted, so we don't have real changes there, but there's something that has happened several times. In dealing with residential leases, that if there's currently a lease on the property, between the seller and a third party, someone else. We need to continue to remember that the sales contract does not impact on that lease between the seller and the tenant. The seller selling the property does not void that lease. And if the buyer buys that property, he's now the new landlord. And he now is totally responsible for that lease, including any security deposit. That's what the lease for residential leases is for. Now, the one thing they've added to it, because we've encountered this, are oral leases. Because many times you'll have a tenant that's been in the property for 10 years. And the last couple of years has been there month to month, oral lease, handshake, or whatever. And so, we need to understand that, we now address oral leases in that residential lease addendum. That was a good thing to address there. But you need to really, if there is a current lease on the property, if you got the buyer, don't go down the Fat and Happy Road. Oh, no, yeah, the tenant's moving out. Their lease is up this month and they'll be out by the end of September. So it's not a problem. Go ahead and in this contract and close it October 10th. Yes, ma'am.
So you said oral leases?
Oral leases. So
Are they have the new owner down to an oral lease?
Yes. yes,
But
good. Well, because in the residential lease addendum, we now address, there's a paragraph in there addressed as oral lease.
on the addendum.
So in the addendum, it addresses oral lease. So if there's an oral lease, we have that information that has to be there.
Okay, and those terms are spelled out on the addendum?
Yes.
Pull that,
Yes.
okay,
Because the reason they added that is because we kept encountering it. The
okay,
Lawyer Committee finally made the change in that because it kept happening.
okay, that's the only one to have anything oral.
Yeah,
Yes.
and we have to remember, there are all kinds of real estate contracts that can be oral. It all comes down to enforceability.
Right,
Now, in the statute of fraud, if it's an oral for the sale, purchase of real property, it's not enforceable. Court won't even hear the case. See, he said, she said, we don't hear about it. But that doesn't apply to a lease. An oral lease can be enforceable.
right,
So the sale of property and the statute of frauds, yeah. So we got different things that happen based on the type of transaction that it is as you work through it. So it was good that they added that. Now, they added the same thing and the next thing dealing with fixture leases. Some fixture leases are oral. I frankly have not seen one. But just because it could happen, they've added the oral part to that addendum, Now, the challenge we do have with, back to my point on the residential lease. If you've got the buyer, they say tenant's gonna be out by the end of this month, you need to make sure you've used that addendum anyway, still used it. Say, oh, we don't need that because they're gonna be, no. We're gonna use it. And you make sure your buyer hears you advise them, don't close until that tenant's gone.
absolutely.
Make sure it's done. Because then, as we get towards the end, say, well, we really sad we want to stay here through Christmas. Holidays are important to family. Now to the fixture leases, it also made the change for oral fixture leases. And I don't even have a thought about what an oral fixture lease is. I don't know what to do. Never encountered one, but evidently it did happen, so they added that. Our bigger problem with fixture leases is we've had this happen at least twice, both cases solar, in which the seller was going to pay off the solar panel fixture lease out of the proceeds of the sale. We don't address that in the addendum, the fixture lease addendum. And yet we need to use the fixture lease addendum because right now, as we execute the contract, there's a fixture lease on the property. I say, well, but the seller's gonna pay off that fixture lease, and out of the sales proceeds, so we don't have to worry about it. But what if the seller has their numbers wrong and also they determine, well, we didn't realize it was gonna be that much. So we just had to pay off this balance and now it's another $10,000. We're not gonna do this, so you need to assume the fixture lease, so. We're making recommendations to the Broker Lawyer Committee to make a change on the fixture lease addendum to address that situation. Right now, we just have to advise if we've got the buyer, we need to advise them, here's the risk. Because if something happens and the seller can't or won't pay for it out of sales proceeds, remember that solar panel company has priority over those solar panels. And the sale of the property doesn't change that agreement, that lease agreement on the fixture lease, just like in a residential lease. So the buyer now owns a property with solar panels in it and may not be personally responsible. Still, the seller may be responsible for those. However, the solar panel people can come in and rip those out of the roof and good luck on that. Yes, ma'am.
Couldn't that be on the seller's a negative on the seller's side? Couldn't you do that at closing?
Say that again.
Couldn't you pay off that lease at closing, within the closing proceeds on the seller's side?
Yeah, I mean, that's the thing. Seller says he's gonna pay off the solar panels out of sales proceeds.
Right. Okay, so that would be done at closing though. I mean, it's not.
Yeah,
like
but what if it doesn't get done?
It's-
Hire owns a piece of property with solar panels on it, and there's a fixture lease that's good for another 20 years. But somehow the buyer has to make sure that there will be assured that prior to closing, this is taken care of. So it's, well, I can't pay it off until closing, because that's where I'm getting the money to pay it off, sale proceeds. And you got a real challenge. Because there's no assurance that the seller's gonna do it. There's no assurance, until we know the kind of lease they have with the solar panel company, they may not be able to pay it off. Some leases you can't pay off. Some are not leases, they're purchase agreements. Which you're not purchasing solar panels, you're purchasing electricity. So there are a lot of things that could happen that it's not what it appears to be. So we have to be careful of it. But until we can get the Purple Learning Committee to make changes on that. And I'm not even 100% sure on what that change would look like. So questions on that? We good? Yeah, I do want us to go to page 2 in paragraph 5. Remember the timing of payment of the option fee and the earnest money is 3 calendar days. Not business days, calendar days. And when we get to the 3rd day, if it's a weekend or legal holiday, it goes to the next day that's not a weekend or legal holiday. We got to that 3rd day with calendar days. This applies to the payment for the earnest money and the payment of the option fee. What I've encountered twice, one here from one out of the Rockwall office, is they say, oh, yeah, and that applies to the option period too. When the option period ends on a weekend or legal holidays, it goes to the next day. It's not a weekend or legal holiday. It just kind of seems, well, that fits. That, not true. Not true. The language only applies to the payment of the option fee and the earnest, not to the timing of the option period. To work through that. We need to make sure we do that distinction. We need to continue to remember that any money that's paid to the title company, if there is in paragraph 5, an amount agreed to for the option fee, any money that goes to the title company first is applied to the option fee. Anything left over goes to the earnest money. So if the buyer is paying it in one amount, they need to make sure it's enough for both the earnest money and the option fee. So if it's not, then you've got a situation where the buyer is not complied with the payment of the earnest money and the seller can terminate the contract. Yes, ma'am.
Can you please repeat the difference between the calendar days versus the option period and the money? So the money, you said needs to be
The
there.
payment of the
Yes.
earnest money and the option fee are within 3 days after the effective date of the contract,
Okay.
3 calendar
Calendar
days.
days. So if it's effective on a Thursday and the title company is closed and you're hand
I
delivering
don't
it,
care when the title company is closed or not closed. And I'm glad you brought that up, because one of the things in the contract, reference in the contract, that certain things have to be done when the title company is closed or open. We just have, here's the time frame. So we got a contract, the effective date of the contract is Thursday, Friday, Saturday, Sunday. That's the 3rd calendar day. So this is for payment of the option fee, payment of the earnest money. So that will roll to Monday, unless Monday's a holiday, which it just was, then it would roll to Tuesday. But it's for the payment of, not the timing of the option period.
But if you do, let's say on the 3rd day is Sunday, if you do pay it on Monday, do you technically not have that option anymore?
Now, it's a good question. The timing of payment of the option fee does not affect the timing of the option period. If the effective date of the contract was Thursday, the first day of the option period is Friday. So if you've got 10 days in your option period, those 10 days start with Friday, the very next day after the effective date, regardless of when you pay the option fee. You could end up saying, well, Monday's holiday, so I want to pay the option fee Tuesday. Well, your option period still, the first day of the option period was Friday. Now, there's another rule that kind of goes along with this. It's Tuesday, because Monday was a holiday. You haven't yet paid the option fee, and you decided Sunday terminate the contract. If the reason you're terminating the contract, or the basis you're terminating the contract is the option period, then it's clear you cannot terminate under that provision until you pay the option fee. So if you're gonna terminate, you go to the trick promulgated notice of termination contract by buyer, that's the very first box you check, you do with the termination option. If that's the one you're gonna choose, as opposed to HOA or self-disclosure or one of the others, that's one you choose, then you have to pay the option fee. Or you can terminate under that provision.
They can just, send the full fee, but they cannot send the earnest money.
Yeah, and they may or may not have paid the earnest money yet. Remember, the buyer, they pay an option fee, terminate on that provision, and never pay the earnest money. Because in this particular case, where we get money at holiday and moved to Tuesday, so it may be that Monday still is a legal holiday, although some title companies may be open. Whatever way, the buyer goes ahead and sends notice of termination to the title company and to the seller on Monday and terminates. We got to pay the option fee. And because they didn't have to bring the earnest money in until Tuesday, say, well, I've terminated the contract, there's no reason to pay the earnest money. Or if they wait till Tuesday and terminate, because everybody's open then, they've got to pay the option fee, you don't have to pay the earnest money. That makes semi-sense. You gotta pull all those kind of semi together. Very good with that. Yeah, really.
I was thinking of a scenario in my head that I've never thought of before, with a holiday involved, is that if you have a shorter option period than the amount of days to deliver the option money to the title company.
Yeah.
So therefore, do you make a decision to give it to the agent?
No,
I guess in my brain, I was thinking, okay, wait a second.
Yeah.
I did a holiday.
so you're gonna have a 5-day option period.
Yep.
Contract is effective on Thursday.
I was gonna say, what if you have a 2-day option period?
Okay,
Yeah, and then you have a holiday,
yeah,
got executed on a Friday,
so
Labor Day, Monday.
all that impacts on
Yeah.
is your option period.
Yeah.
Your option period still started on Friday,
Right,
and you had, so you had 2 days in your option period, so Friday, Saturday. Your option period ended Friday.
Yeah.
Now, if you decided on Friday or Saturday to terminate,
Okay.
you gotta pay the option fee,
2,
the title company,
but if they're not working, so accept it,
doesn't matter. You gotta go to the terms of the contract.
okay,
You cannot pay the listing agent or the seller.
right,
You have
that's,
to pay the escrow agent.
so do you go drop a
Thank you for
check
being
in the
here.
night slot, or what do you do? You go drop a check in the night slot, or what do you do? Like, I'm just curious, like,
Well, what you actually do is if it's a title company you do business with, you call one of the people there and you
yeah, okay, got it, that's,
and you do, and we've done that.
yeah, that's, I was just thinking that you just.
Just meet with them and say, here's the money and you know, receipt this.
Got it, okay,
You know,
Lot of time it's online.
Pardon me?
Lot of time online.
Yeah, you can do online, many of them have Zelle or something like that,
okay.
and you can pay them through that. So you can work through some of that.
Okay,
Here's the other challenge we get to though. Let's say we've got 4-day option period. So Friday, Saturday, Sunday, Monday, this holiday. But short option period, you want to get right on with the inspections. So you're gonna get the inspector out on Saturday. And the listing is, oh, no, I don't think so. You haven't paid the option fee yet. You don't get to do an inspection.
I don't think you get.
One has nothing to do with the other.
Yeah.
Paragraph 7A deals with the inspection. And yet you'll have listing agent sellers say, you know, until you pay the earnest money in the option fee, you don't get to inspect the property.
Thanks.
And they're wrong. And but we do that battle on a regular basis. And you know, I call me when it happens. I'll call the broker, I'll call somebody. And I'll be really respectful. I rarely use the word loser. Sometimes I do. Have to work through that, but it is, people tend to pull those, they tend to pull those things together. And say, well, yeah, you can't do this until you do this, and that's just not true. It's just like I see a quizzical look there.
No, I'm not sure what you say. You cannot do the inspection.
Oh, you can,
You
you can. As soon as we have that executed contract on Thursday, everybody signed off on it, executed the title company on Thursday at noon. That afternoon, you start doing inspections. Immediately, under paragraph 7A, once we have a contract.
Hey, Bob,
Yes,
Bob,
ma'am.
it's
Question.
Adrian. How are
Yes,
you?
Adrian. How are you doing?
Good. I
Thanks
have
for
a
being
question
here.
on that. In that scenario of if you went under contract on Thursday and there was a holiday on Monday to turn your option earnest money in, but at the time you went under contract, you got the seller, you received the seller's disclosure and you received the HOA docs, but you decide to terminate because of the seller's disclosure, do you still have to pay your option?
Okay, now you threw in an extra thing there, and that was the HOA. Seller's disclosure doesn't create a right for termination. Nothing on the seller's disclosure unless you're gonna go after
Right.
the seller for fraud. But the
Right.
HOA docs, in your case, you got the HOA docs. So you have the HOA docs. Once you receive them, you now have 3 days to terminate for any reason. So you can say, well, I'm gonna terminate, and you check off that box on the notice of termination contract by buyer, check off that box. You don't have to pay the earnest money or the option fee. Because you're
You
not
said-
terminating under the option fee.
Okay, gotcha.
The
All
option
right.
period.
Great. Okay, thanks. Appreciate it.
Now you will, actually, I will get fussed at. But we will get fussed at. I mean, I get fussed at on whoa, that's just not right. I said, yeah, but that's what your seller agreed to.
I always say.
That's in the addendum. That's what's agreed to. That's it. That's there.
Okay.
Yeah,
So-
Yeah.
So we were taught in Ignite, or the last Ignite, when I just went through, that the option, if you have not received the seller's disclosure, actually received it, whether it's up on MLS or not, that you check, have not received it. and then-
7B2.
Okay, and that gives you 7 days to get it to you and another 7 days for you to review it.
So
And then you
I don't know
can-
where you're getting the 2 7 days. And
Okay.
Adam is really good, so I'm not going to say anything.
Yeah.
So here's the concept. You don't have a right to terminate based on what's in the seller's disclosure notice. Your right to terminate is based on the receipt or non-receipt.
Okay,
If in the contract 7B2 is checked off,
okay,
says seller doesn't have it.
okay,
So, I mean, buyer doesn't have it. So the buyer, right now, we have an executed contract on Thursday. And the buyer does not have the seller's disclosure notice.
got it?
If you've got a number of days, as you work through the process, technically, the buyer has rights to terminate based on the receipt or non-receipt of the seller's disclosure notice. So technically, he's got that first 7-day right of termination. Now, what we're hearing from a number of attorneys and some brokers who, otherwise respect, they say, whatever the number of days you have in 7B2 in that blank, you've got to give the seller that amount of time to provide the seller's disclosure notice. And you can't really terminate until that time frame is passed. Now, that's true under the Mantua HOA addendum in A1, where you've got a number of days in there, dealing with receipt or non-receipt of HOA. I don't believe it's true on the seller's disclosure notice. It really doesn't matter, because you're sitting there and you're saying to the seller, okay, I understand that you're saying I don't have a right to terminate yet. We've got 5 days in the blank in 7B2 for you to get me the seller's disclosure notice. You know the buyer's going to terminate, and they have a right, because once that 5 days is up, based on what you believe, they've got another 7 days to terminate for any reason. You're saying, knowing my buyer's going to terminate, let's go ahead and keep the house off the market. You've got 72 hours to change the status in MLS, by the way. Knowing that they're going to terminate, or would you rather, let's go ahead and terminate now so you can get the house back on the market? it's silly knowing the buyer's gonna terminate you, well, but technically, even though you're not gonna buy the house, you really can't give us notice for another 12 days. Really? That's stupid. So if they wanna push that button, you say, okay, let's look at the logic of this. Why are you wanting us to wait on that? So makes no sense. As you work through this. Anybody, somebody says though? You gotta go?
Gotta go.
Hey, you'll do good.
Learn something new every day though.
Me too. So everybody good with the timings, first money ops fee, how all that works? That, okay. The other area that I do want to deal with, go to page 3 of the contract. It's not a change situation, but it's something, need to have some awareness of. And that's dealing with objections. The buyer is limited on the objections in the big blank in dealing with 6C. Or 6D and objections, you got a big blank and a small blank. They're on page 3. If the big blank stays blank, then the buyer is restricted on what they can object to. Because when you see the language under objections, Army objective right to defects exceptions covers title disclosed on the survey other than. So 6A1 through 7, and then commitment 6A1 through 9, buyer has no right to object to anything in those sections. Which is essentially everything. But if the buyer puts something in the big blank, he now has created a basis for objection. But it needs to be something specific. Not residential use or not, it can never be conditional. Well, based on lender required repairs, nothing can be anything else. So the buyer needs to think through what they want to do. That we want to build a detached garage, or we want to put a pool in the backyard, daycare, anything that you buy, but it needs to be something specific because you're going to cloud the offer. Seller may look at, hey, well, it's a weasel clause, you're just trying to find a way to get out of the deal. So it needs to be real, but it does need to be there because it creates a right for objection. Creates a basis for objection. Now, the small blank in 6D always needs to have a number of days. Never let it stay blank, never let it be 0. Because we don't know what 0 even means in this context. We need a number of days. The small blank in 6D needs to have a number in there. I don't care which one, but it needs to be a number. Because this is one of those things that when a buyer receives the last of 3 documents, commitment, exception document, and survey, they have this amount of time to object. I don't know what 0 means in that context, what it is. So you gotta have a number of days. Whether you have anything big blank or not, or you always have to have something small blank to do that. And remember, there's no obligation to the seller to do anything based on the buyer's saying, well, I can object if I can't do this. But it's fine. It's your job, buyer, to determine if you can do this or not. There's no obligation on the seller's part. Cynthia?
Give me something that I can say, if it has a swimming pool, what am I going to object to?
Easements.
Oh, I didn't think of that. Right.
And that's the most common problem you're gonna have. You've got easements that get in the way of building a new ground pool. And if you didn't put swimming pool in that big blank, you don't have a right to object to easements.
Let's address the timeline of making your objections stagger, so you have even more time after the option period. What time do I need to cut off all of, like there's an HOA, there's a commitment, there's third party financing, and I'm trying to stagger them so I have more doors to open from because my buyer is weaselly. How many days prior to closing do I need to have everything firm and no more outs for the listing agent not to give me pushback?
You have the buyer or the seller?
I have the buyer.
I think it's interesting the way you want to stagger them because they each are independent rights.
They are.
And remember, the rights of objection is not automatically a right of termination. Make an objection, seller doesn't cure it, then the buyer has rights, termination under that. And typically the time frame for objections is a fairly short time frame, 3 days, 5 days. If it's a longer time frame, if I'm the listing agent, I'm saying, what kind of games are they playing here? Are they thinking that this right of objection is tied to the effective date as opposed to the date of receipt?
Well, I don't want them to all occur during the option period, right?
Don't what?
I don't want them to all occur during the option period.
You want them to do what?
I don't want all of these to occur during the option period, these deadlines.
So I'm really having trouble pulling together the time frame for objections to the option period.
So that's I'm not clearly communicating. The option period is 7 days. Let's
Okay.
just, for instance, I'm gonna want the third party financing to be 21. I want it outside the option period, right?
Okay.
I want the HOA sometime between the option period and the third party. I find my buyer is really confused if I have all these
Okay, so,
periods terminating at the same time.
okay, so let's look at the HOA thing. The more time you give the seller on the HOA, because on the HOA addendum, buyer's rights of termination don't start until that time frame ends. Or you put a longer time frame in there, you've affected your buyer's right of termination. I think a shorter time frame is better for your buyer.
You would have them run concurrently with the option period?
No, I'd say a shorter time frame is better. It might be less than the option period. The key is, remember, it's your buyer's right of termination will be tied to the receipt of the information. Or the number of days in the blank if you choose A1, hopefully you have, but you choose A3. So as you go through that, and remember, let's say you put 21 days in the major HOA addendum. What happens to the transaction if the seller gets you the subdivision information in 5 days? That starts your 3-day right of termination. Not the 21 days.
I didn't think title companies could respond with an HOA certificate quickly. Can they now?
Not the title company, it's HOA managed.
Yeah,
Okay, I'm sorry, I didn't know the HOA is not responsible.
Yeah, some of them they don't. Some of them, even if you put 10 days in there, they're gonna charge you a rush fee.
That's what I'm
So
saying.
that is a challenge. But I'm still trying to think through, and we may have to have a side conversation. Still trying to, I understand the basic concept of wanting to create rights for your buyer as you work through the process, which means they need to understand each of the individual rights and how they would use them. And when they put a certain number of days in each of those rights, they need to understand how that affects the offer as it's being perceived by the seller. I think that's a good question, but I'm still having to think through it as you work through it, so.
What is a good number for the 99? Please.
I think a shorter time frame, unless we get to the concept that is bringing up 3 days, 5 days, because remember, it's all tied to the receipt of the information.
Yes.
So once you receive the information, that's gonna affect your termination.
But it says seller expense.
Yeah, seller's expense in A1, yeah. I like A3. But in A1, so, yeah. Okay, guys, I think we're out, we're about through. Thank you very much for being here.
Thank you so much.
I think Austin did a great job.
Yeah.
So compliment him on all that. And,
Okay, but thank you, Bob.
thanks, Bob.
Thanks so much.
This is my fourth copy.
I got it for tonight and then just.
Don't have the same.
I was there, it was hard. Thing this morning, earlier, but then before that they had at night, it was 5 to 11. Yeah, I'll
So-
start first.
Here's one of the challenges
I'm a baby.
That's good, I mean.
in dealing with 7B2.
Yes, sir.
And I think
It's a lot, but I'm excited.
semi-agreement. This is a different situation than the number of days, how we use that in the HOA.
Yeah.
So I see the number of days here as a suggestion.
Okay.
In my opinion,
I'm very excited, I really like it.
until the buyer receives Except the seller disclosure notice, you have a right to terminate.
Okay.
So if your seller delivers the terminated receives notice. Or prior closing of her account. If buyer does not receive the notice, buyer may terminate his contract at any time prior to closing.
Easier.
Here's my question. So what I see that as meaning is that if you don't receive it, you don't have to wait till closing to say, well, I haven't received it yet. And so I can terminate now. I think that from day one, the buyer terminates. It doesn't happen.
Right, got that. That makes sense.
And so he's got that right. I think 782 agrees to 7-day right of termination.
Okay, because it says that if he doesn't get it, he may terminate for any reason.
Yeah, but if the buyer does not receive it, he
Right?
may terminate.
Okay.
So I think right from the beginning. So
Yeah.
I think one of the things that, it is confusing, but one of the things that we really are dealing with in 7.2 in the seller disclosure notice
Your camera roll.
is
You're
that
using
sometimes
a post, so
sellers are having a challenge, you're traveling a lot of forever.
Sure.
So on the buyer
That's
side,
kind of your base.
if you wanna put a
your
longer
quick
period of time in
postings,
there,
and there's two ways
your
to
buyer
do that.
says you can drop
Either
it.
scroll to the side.
So if you put, let's say you put 10 days in there
Okay.
and the seller finally in 10 days gets to the buyer.
Is gonna
Well,
be
you're
like,
7 days.
um,
Part closing.
yes, and then July.
So you can take that.
Yeah. Yeah.
An additional step
Yes, yes.
above when you receive.
Yes, sir.
So if the
Okay,
seller,
that's
you got a contract, the seller immediately,
Yeah.
the seller immediately, the next day after the contract gives to you, was got 7 days.
Yeah, but I've never done.
So I've heard people.
Yeah.
I learned.
It's so-
I learned a lot.
Okay, we'll see what the lenders will do.
Okay,
Okay,
yeah.
good luck.
Thank you, sir. Thank you.
Go for live, it's not live. But just the basics, right, is the story, you can either take a picture like that. Or like this one is like already automatically like your camera roll.
Yeah.
And this one is to take a picture from Instagram, right? And you go through and you hit next here, you can edit it however you want, those are. And then here is where you do all your extra stuff, so you have your caption, so you can tag people.
Are you guys plotting? You look like you're plotting.
Yeah, those are up here, right? Yeah, so you can tag people, right, when you hit there, and then you can just look up
Okay.
different accounts and stuff.
Or what?
Tagging is extra, it's kind of like on Facebook, they're like, you're, yeah, same thing. Products, don't worry about that.
Contract what?
So mine is specifically a business Instagram, because they have that as well. So there's a little bit more, but.
You're in contract.
Binder, which tells you,
And so in the contract, had not
if you
received
have an event. So it's like an open house or something, you have this
So you
reminder,
gotta-
so you have your name,
that you haven't
so you
received.
have an open house going on Saturday, you post Tuesday. And then the location, this is the big one that you were talking about. This one already tells, they know where you are, right?
And the contract.
And it's like, no, I'm here, I'm here, or you can hit your location, you can look at anything. Anyway, you could.
Contract, promulgated contract.
Yeah, I think that's just, but I'm sure. I don't know that they, yeah, so they don't go as specific as that, it's kind of a,
I see.
you know, but you can do this,
Okay.
right? And so then you can have music, whatever, but that's gonna be your big thing, that and the caption. And then you post, and that's it. It's a lot, but it's fun, it's great. Yes, I would love to, please, oh my goodness. Yes, it was so nice to meet you. Me too.
Happy to, you receive.
Well, whatever the buyer decides they want to request repairs. This will be attached to the track promulgated amendment. Yeah. So in the amendment form in item number 2, we're talking about repairs, you say see attached repair request list. And then the buyer. Now, your role in advising the buyer and negotiating the transaction is help them understand what's really important to them, but hopefully they've talked to the fact.
Yes, and they told me, they need me to negotiate the most important thing.
They've got to decide, not you.
Yeah, I told them.
They have to decide that. They have to decide based on, are they gonna live in the property? Or are they buying it as an investment?
Oh, they wanna leave it.
Okay, so they have to decide based on how they're gonna live in the property, what is important. Clearly, anything functional, electrical, plumbing,
Yeah,
all
I
that.
told them that,
So-
yeah.
so they've got to decide, and they've got to tell you, and I want to see it on the email, so you've got documentation. Here's what's important, here's what they want you to negotiate, what you'll do is you'll complete one of these. Based on what they want to do, you'll attach it to the correct promulgated amendment form.
If you don't want to,
So, you know, you did it by the end of January.
they want me to negotiate, and I showed them one kind of item you want to negotiate. The worst item. Because the buyer, he is a constructor. So he said that he wanna fix all
Okay.
the small items.
Okay,
So that's why I talked to.
the buyer still has to decide what are the worst items, what are the important items, and then they have to decide that. They can't tell you, so just negotiate all the important items, no,
Okay,
because now you're liable. They've got to decide, and they've got to tell you, here's what we want, here are the big items. That as a contractor, I can fix these other things, it's not a big deal, here are the big items. And we want you to negotiate, and the way they negotiate is in writing, don't just have a conversation, because it's not important, I didn't do anything.
Yeah, I do a lot.
You've got to get them off the fence here, they have to tell you.
so I have to send them the older report and they.
You don't have the report,
Yeah, they have a report.
so they have the inspection report.
Yes.
And we talk to the inspector about what's important,
Yes, I.
and they, as the buyer. talk
Yeah,
to the
they talked
inspector.
to the inspector and
Okay.
he told them that even all the roof has to be replaced.
This is a condominium,
It is a townhome.
well, that's different. Okay, because they own that roof on townhome, they don't own the condominium. And they need to find out, is there's an HOA,
It is not any HOA.
if it's a condominium, there's an, we started talking about this as a condominium. It's not a condominium,
No, it is a townhome.
okay, and so you're telling me this townhome does not have an HOA?
No. It doesn't have an HOA, so
Where is
that is
this, where is this project?
it's in Irving.
There are several of them attached to each other, or is
Yes.
it individual?
No, it has it has like 10 more attached.
Okay,
Yeah, it's a small townhomes.
okay,
It's not a bigger, but
so you're using the 1-to-4 family contract,
yes.
okay. So back to the first issue, buyer has to decide, you
Yes.
cannot do it, they have to decide.
Yeah,
But
they
you
have
understand,
decided.
not only is this important from a liability standpoint, it's best service to them. Because they say, well, just pick out the worst items, and you pick out the wrong ones. It's not good service to them. They need to understand, especially with someone who's a contractor, he should know what's important. Yeah, here's an electrical issue, here's a roof issue, here's a whatever.
He does everything and he went to the inspection and I went
Okay.
to and he said, because the inspector says that we need to see if it is not a link.
Slab leak,
Mhm. And he said, no, just leave it like that. He said,
Who said
I